I don't believe he's entitled to therapeutic justice because of his gun case, but he does have a drug problem.
You were cooperative. You told him the gun was there.
All right, court is, and are there any applications in this case or no?
No, Your Honor.
All right. Court is calling 2014 CR 3195 and 2024 CR 3196, State of Texas versus Sonny Valenzuela Jr. Could I have parties announced for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
Anton Hyde from Mr. Valenzuela.
And are you Mr. Valenzuela?
Yes, sir.
Counsel, have you received all the discovery and did you review it with your client?
I certainly have, and I certainly did, Your Honor.
In each cause, the court will find that the state is in compliance with discovery. Mr. Valenzuela, in each cause, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive the reading of each indictment, Your Honor.
State, are you proceeding on the indictment as presented in each cause?
In the cause number that ends in 3195, we are waiving the repeat enhancement allegation, Judge.
Any objection?
No objection.
And in the cause number ending in 3196, we are proceeding with the indictments as presented and the habitual offender enhancement, Judge.
All right, Mr. Valenzuela, in each cause number, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
In the cause number ending in 95, you're charged with unlawfully carrying a weapon with a felony conviction. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And cause number ending in 96, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. If the state is able to prove up the habitual enhancement allegations, your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And each cause number, if you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering these agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into pleas in each cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has in each case, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do so believe.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do so believe.
Mr. Valenzuela, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea in each cause number, the cases will run concurrently. Your punishment is to be assessed at 5 years in the prison. The state will take in consideration 2024 CR 1869. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
And each cause number, did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that? You're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have been no such motion.
Then in the cause number ending in 95, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number ending in 96, how do you plead?
Guilty.
And with regards to the enhancement paragraphs, how do you plead? True or not true?
True.
State, do you have any evidence to support the defendant's plea?
Your Honor, in each cause, offer State's Exhibit 1 in the attachment.
Any objection?
No objection, Your Honor. In each cause, I've had an adequate time to go over those with my client.
All right, in each cause number, did you review the documents entitled waivers and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And each cause number, the court will find you guilty. And the cause number ending in 9-5. I'm sorry, in the cause number ending in 9-6, the court will find the enhancements true, also based upon your plea of true and based upon State's Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I don't believe he's entitled to therapeutic justice because of his gun case, but he does have a drug problem.
All right, Mr. Valenzuela, things may change. I could still refer you to the therapeutic community. However, you'll still have to request it and they may or may not reject you. Would you like me to have you referred to the therapeutic community?
No, ma'am, that's fine.
All right. Then, and cause number ending 3195, as previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with cause number 2024 CR 3196. The court will take in consideration 2024 CR 1869 and give you credit for any time served. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And the cause number ending in 3196, as previously stated, the court is finding you guilty. The court will follow your agreement. The court will sentence you to 5 years in the prison. Court will give you credit for any time served. This is run concurrent with 2024 CR 3195. Take in consideration 2024 CR 1869. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
35.
All right. Either you're going to take care of this drug problem or you're going to continue to come back to court. And you may find yourself living in the prison. You understand?
Yes, ma'am.
If you have a drug issue, when you're released from prison, there are plenty of free places for you to go. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
You're welcome.
Should be excused, Your Honor.
Yes.
Thank you so very much.
This is file number 24516FY, People versus Philip Robert Evans. Mr. Evans is here with his lawyer, Luke Lofsinger. He lives in Jones, which is in Cass County, and he got stopped by a trooper on March 26th in possession of a revolver in a motor vehicle. That is a felony, commonly known as carrying concealed weapon. That's punishable by up to 5 years in prison and requires forfeiture of the weapon. The bond information sheet says this started out innocently enough. I think it says on the listed dude, troopers completed a traffic stop on the suspect vehicle for a brake light out. This driver admitted to having a gun in the vehicle and did not have a CPL carry license. Mr. David Marvin, the county prosecutor, is here, and he has agreed to dismiss that felony charge for a plea to improper possession of a firearm. He does this actually quite often if the facts merit it. It reduces it from a felony to a misdemeanor. It does require the forfeiture of the gun. It'll be destroyed by the Michigan State Police. And that would resolve the case. Is that correct, Mr. Marvin?
Yes, it is.
You agree, Mr. Knopfinger?
Yeah, Judge.
Shana, I just sent you a message. Thank you. Mr. Evans, do you understand if you do plead to this misdemeanor charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have a right to be represented by an attorney. Mr. Marvin, could you send me the police report in this case? Mr. Knopfinger is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
All right, were you pulled over in a traffic stop here in St. Joe County on March 26th?
Yes, Your Honor.
Where were you going?
I was going to the laundromat right there in downtown White Pigeon,
Where are you coming from?
my home
Which is in
in
Jones?
Cass County and City Township of Jones.
All right, and they just stopped you for a brake light. Doesn't sound like anything else was going on. And so you told them you had this gun in the car?
Absolutely, Your Honor.
All right, well, tell me about this gun.
I carry it for personal protection. I was under the impression that Michigan was open carry. I understand now that after divulging into the law, which I should have done long before then, that the very minute I got into the vehicle, it was considered concealed.
Yes.
That's where my mistake was made, Your Honor. I had the gun on my hip. It was an open plain view. I was going to the laundromat. It was late in the evening. And I really don't like going into the laundromat that late at night without it. It was a simple mistake. But
Judge, Mr. Evans used to live in Tennessee for a long while, and as far as I can tell, not a lot of restrictions on handgun possession in the state of Tennessee.
Well, you're right. Once you put it in the car, it becomes a concealed weapon. So you can carry a revolver on your hip and it's not unlawful. You don't need a permit. However, once you cover it up with a coat or once you put it in a vehicle, it becomes a crime. But, and I can see why Mr. Marvin would have reduced this. You were cooperative. You told him the gun was there. Now, what was this? A Bulldog 44 caliber revolver?
yes, sir. Charter armed 44 caliber revolver, 5-shot revolver.
And you had some ammunition also?
It was loaded, yes, Your Honor.
Everybody needs a 44 caliber when they go to the laundromat.
It's considered the Bulldog. It's considered the 44 special, Your Honor. It's a same frame as a 38 revolver,
All right.
just a bigger caliber.
I don't have a criminal history. Mr. Evans I don't know, has any history.
Your Honor, that's why in part when I looked at this, he has no criminal history. So he's in his fifties. He's never been in trouble. He's a law abiding citizen. His cooperation, it's clear that he wasn't hiding anything. As a matter of fact, he even gave consent to search his vehicle after this. So we all have the right to carry a gun. We just have to follow the laws. And the charge here is exactly what happened, and that is just the misdemeanor of improperly carrying a gun inside of a vehicle.
All right. Well, you haven't been here since I've been judge. Back in the day, you had some traffic tickets in the 90s when I was still prosecutor, but so what do you do over in Cass County?
I'm a welder, Your Honor.
Who do you work for?
I was working for Rance Aluminum. I was laid off 3 weeks ago, Your Honor.
Sorry to hear that.
Yeah, me too.
You did post $100 bond. Did they take you to jail?
Yes, Your Honor. Spent one night in jail.
How was that?
Well, since 1991, I can say it's changed a little bit, Your Honor.
Easier, isn't it?
Ain't never easy, but yeah,
No.
it's a little bit different. I've tried to be a model citizen, Your Honor. I don't get in trouble.
Well, we've got a mechanism for you to get a permit.
I tried doing that, Your Honor. As a matter of fact, the Cass County Conservation Club offers the concealed carry classes.
Yeah.
I need to get enrolled in that ASAP if I could.
Well, you're gonna lose this gun. I'm gonna give you 1 day jail credit, 1 day. There's a $75 fine, $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee, which is $350 minus $100 of bond, which is $250. I asked the clerk to see if they could get me a criminal history from Indiana or Tennessee or anywhere, and but apparently, according to Mr. Marvin, he doesn't have any, and so I understand why he certainly took this plea. The gun is forfeited,
I understand that, Your Honor.
and the ammo also. That's by statute. At one time, they take the guns and then they would sell them to police agencies and others. Now they're by law destroyed. I saw that some Flint or some other city, somebody sent me an article that they were selling the guns that they took, but we don't do, the state doesn't do it.
Criminal history has been sent to you by email.
I see it. Oh, here's the one from, yeah, it's blank. So very good, sir. Well, lesson learned. You did several things right. You were polite, respectful of the officers. You disclosed the gun was there. People get shot or stuff like this. Then you also consented to the search of the car, which you didn't have to. It shows you didn't have anything else going on. Nothing was illegal. So lesson learned, you got a fine to pay. You spent a night in jail, and you owe $250. Can you pay that by May 10th?
If I could have a little longer, well,
Let's go to June 10th.
I was gonna say, I was gonna say. Thank you, Your Honor.
If you need more time, come see me.
You can do that, Your Honor.
The goal is to get the fine paid, not to lock you up. For what it's worth, I don't see a lot of criminal histories that look like yours. Because people that don't have criminal histories don't come in here. So you got nothing on there but this.
Now, is this, if a question?
It's gonna show as a misdemeanor, but it is gonna show as improper carrying of a firearm, not a CCW. All right, Mr. Evans, thanks for your patience. You got to watch some other court this morning, part of your legal education about things that are going on here, but you're free to go.
Thank you, Your Honor.
All right, good luck, sir.
Court is calling 2023 CR 8784, State of Texas versus Heather Martinez. Can our parties announce for the record for the state?
Jason Garrett, you're up.
Defense?
Todd Coronado.
And are you Miss Martinez?
Yes.
Probation, this is an application. All right, counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Martinez, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, 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 wait, count two, proceeding on count one alone.
Any objection?
No objections, Your Honor.
Ms. Martinez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft, 2,500 to 30,000
Yes, ma'am.
of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
That's correct, Your Honor.
Ms. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Very much.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count one. There's a $1,500 fine. State recommends deferred adjudication. There's to be restitution of $400 to Peter Sam. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, it is.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be granted for a term of, no,
We're requesting 2 years.
all right, for a term of 2 years. There's to be a TAP evaluation, 120 hours of community service, restitution, and no contact with Peter Sam. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State exhibit number 1.
No objections, Your
All
Honor.
right, state, you may continue to confirm. Showing you what's entitled waivering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Off the record for a moment. Have y'all been called up for a panel? Okay. All right, thank you. All right, we're back on the record. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, she's looking forward to trying to get this case behind her and getting it dismissed if you grant her deferred adjudication. So we do ask that you follow the recommendation.
All right, so why did you take this vehicle?
He was a friend of mine. He let me borrow his vehicle. I just kept it longer than I should have. It was my bad judgment. It was just,
Why didn't you return it?
honestly, I was using it for work and it just, he was so nice. Like he let me stay in his house. He was helping me get back on my feet and it was just bad judgment. I didn't think he really mind. He was out of town working. It hadn't been a problem until that time.
All right, so where did you work when you say you were
I
using it
was
for work?
doing DoorDash. I was doing DoorDash with his vehicle.
Okay,
Yes.
where?
Right there in Congress. Where we lived for, I was staying with him in Congress.
All right, so why does it say in the police report that Sam stated Martinez has been posting on Facebook all the locations that Martinez is currently traveling to and is currently en route from Houston, Texas?
I never went to Houston, ma'am. Never.
That's what it says. From Houston, Texas, back to San Antonio.
I never went to Houston, not ever. I don't even know anybody in Houston.
So how many children do you have?
I have 3,
Ages?
28, 26, 24.
Do you have any grandchildren?
I do. 1 grandson. He's 13.
Age?
13.
When's the last time you had employment?
I was employed right before I came.
I'm sorry, what?
Right before I came to jail, about 3 weeks.
Doing what?
I was a housekeeper. I keep cleaning houses.
So when's the last time you used drugs?
I haven't used drugs in over a year.
And what was that?
I used to do cocaine.
And what else?
That's it, just cocaine. That's it, just cocaine.
All right, so you're saying that's it?
Yes, ma'am. That's it.
How far did you go in school?
I graduated high school.
All right, so what are you planning on doing with the rest of your life?
Actually, I'm doing way better now. I found a good employment. I like my job and I met a great man and I'm just in a whole different boat. Before I was just struggling and staying place to place and I didn't have any stability and now I'm just in a whole different place right now. Like this,
So who are you staying with?
I'm actually engaged now. And I'm staying with my fiance and his family.
So how long you been engaged?
We've been together almost a year. We've been engaged about 4 months-ish. 4 months.
So you're staying with his family?
Yes, ma'am.
In a house with his family?
Yes, ma'am.
So he doesn't have his own place?
Well, we're trying to get our own place. He had an apartment that went bad and it's just a lot of money that we didn't have to move to our own place. We tried to get an apartment together, but that back money he owed for the apartment that he lost was like $8,000 and we didn't have that. And then put the down payment and all that, we didn't have it. So we're working on.
So let me ask you this, and this is just a side note, something for you to think about.
Yes, ma'am.
Let's say you break up. Let's say he's just like, you know what, I don't want to deal with you. And his parents are like, well, you're not with him anymore, so you can't stay here anymore. What's your second option?
I mean, I have a job now. I mean,
I'm sorry, what?
I have a job now. Like before I was just working DoorDash, like here and there, a couple of hours to get money through the day. And I just am in a different place now. Like I just feel better about me. Before I was just, my kid's dad had passed and I was just going through a bad spot. That was it.
All right, this is what the court is going to do. $1,500 fine probated, 2 years deferred adjudication. There's a $400 restitution to and no contact with Peter Sam,
Yes, ma'am.
regular reporting by Zoom or in person, the UA hotline, top evaluation out of custody, proof of employment, within 30 days. There's to be no employment as a home health care provider or with minors. And the person that you're working for cleaning houses, are they aware that you're charged with this?
Yes, they are aware.
120 hours of community service restitution. Field visits. One time per month for 3 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
I'm just in a different place now. I didn't remember my lesson. I know that was my fault.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and
Yes,
did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. In order to be successful in this court, communication is key.
Yes, ma'am.
So if there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court.
Yes, ma'am.
And if you are thinking about using, then you need to call your probation officer. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you so much. I appreciate you.
All right, you're welcome. Thank you.
Maybe excuse?
Yes.
Thank you.
Good morning, sir. Dear John William Cap.
Yes, Your Honor.
Of course, I know you. This is Judge Middleton. Your lawyer, Luke Nossinger, is here with me. And Prosecutor David Marvin. Your friends are here. They've been waiting patiently all morning to see what we're going to do here. So just to let you know, you do have some people here that are in your corner. This is file 24513FY. Mr. Cap, you're charged in this case with possession of methamphetamine, home invasion in the third degree, conspiracy to commit home invasion in the third degree, possession of ammunition by a felon, and being a habitual offender. Mr. Nossinger has advised us that you wish to have a preliminary examination in this matter, which is your right. This is a pre-exam conference. The preliminary examination in this matter would be set for next Tuesday. 4924. Record made at pre-exam, Dave Marvin and Luke Knoxfair. Is that true, Mr. Cap? You wish to have your preliminary examination next week?
Yes, Your Honor. Yes, Your Honor.
All right, your bond is $15,000 cash or surety. Last week or so, I gave you a sentence of 30 days, credit 10 or something, 20 days to do, and that time is probably coming up. Anyway, Mr. Nossinger indicated he wanted to address the issue of your $15,000 cash or surety bond. So we're going to set this for prelim for Tuesday, April 16th. At 1 o'clock. Mr. Marvin, is there a plea offer? Well, I guess that can be discussed. I'll just leave it for now. Luke, now, I don't know very much about this, Mr. Marvin. The magistrate spoke to me about it.
Recently, or you mean when it happened?
At the day it happened. That he was out at this property. All right, so the magistrate was frustrated and we'll talk about that in a minute. Anyway, bond is set at $15,000 cash or surety. Mr. Nossinger, you wish to speak to the bond?
Yeah, just a couple things, Judge. I want to talk about, it's currently said, the court said 15,000, 10%. I want to talk a little bit about the home too. I know that there are charges and Mr. Cap can test them, but it's important to know that the
Your
home-
Honor, I'd rather wait for testimony in a prelim. This is not the time for the attorney to give the court information about a case that's not a prelim.
One of the things the court considers is the charges as they are, Judge, and I know that these facts are to be litigated, but I think it's important to know that the home is vacant.
Just. All right. All right, the bond is $15,000 cash or surety. The magistrate was frustrated. We keep seeing Mr. Cap. He's in custody. These are the charges he's booked on. No license ever applied, 24530T. We took care of that one last week. Larceny over 100, but less than 1,000, 232351. We took care of that one last week. That was a felony reduced to a misdemeanor. And he's got a few more days to do on that sentence. Then we have these charges: possession of an ammunition, conspiracy to commit home invasion, conspiracy to commit home invasion, fail to appear, breaking and entering, possession of methamphetamine, and receiving, concealing stolen property. Those are the things he's booked in on. As far as I can tell, the only thing that's pending is this one. He also has an ordinance case and some other stuff that he got behind on, and he's on some sort of payment plan. This was represented to me that they were at this residential property taking stuff, and the people saw it on their camera and came home, and there they were. Mr. Cap's MO is generally, it's all a big mistake. It's not my fault. And it's a misunderstanding. And I guess that was the same circumstance here. Mr. Marvin just reduced a felony to a misdemeanor in the earlier case. And I think he's ready to draw a line in the sand with this case. So that's where the bond was set. Give me 1 minute. Hello, booking. Judge Middleton calling. Can you tell me what John Cap's out date is on his current sentence? That's today. Thanks. Bye. His out date on his current sentence is today. All right, Luke, I'm sorry. I keep interrupting you.
You're fine, Judge. There's a lot going on here.
So his bond didn't matter because he'd been sentenced, but that sentence is done today once they add in good time. So now the bond is the only thing that's keeping him in custody.
Yeah, that's right. And I just did want to note too, what I was saying before is that the house is vacant.
Your Honor,
There was a
he's
fire.
talking about the merits and facts of the case, and we've got a prelim. And it's not appropriate for this attorney to testify to you the condition of a home. That's part of a record that's going to be next week. This is twice now he's tried it. It's not appropriate.
All right, and are you objecting to the reduction of the bond?
I am, because we've had cases in the past that have been repeatedly pushed out and adjourned because he didn't show. And I'm afraid it's going to happen again. I have witnesses that come here. We spend all the time and effort, taxpayers' time, money, and effort for him to not show. And I think the safest place for everybody and the quickest way to get this done is to keep it on for next week and have him sit where he is.
All right. Luke, I'll let you finish making your record, but what I'm going to do is I'm going to continue this motion till next Tuesday. Then everybody can argue the facts. Mr. Marvin's correct. Mr. Cap doesn't exactly abscond, but he's had a habit of not showing up when he's supposed to here in 2024 and late 23, and cases had to be redone and witnesses were here unnecessarily. And and this is it's got a methamphetamine component. It's got a home invasion component. It's got an ammunition by a felon component. And it's got a habitual offender component. Plus he was on bond on the earlier cases when this one occurred. So the bond was set by the magistrate in that amount. So I'll let you speak your piece, but what I'm going to do is continue this to next Tuesday.
Sure, I do think it's important, and I do think this is absolutely relevant as the facts and circumstances. Yes, bond can consider much more than admissible evidence. I'm an officer of the court, reviewed the report, spoke with my client. There was a house fire there. It was unoccupied. It was vacant. So I think that's important. Can be considered a bond hearing. So
Well, but it wasn't his. And so that's the same thing that's always there. It was in somebody's dumpster. It was this. But it wasn't his.
it is, I just think it's important too for the court to consider that if there's a home invasion of an occupied where someone is living, they may not be there at the time. I think that's an important distinction.
All right.
So I wanted to draw that out. I also wanted to mention to Judge that Mr. Cap is on SSI disability. I was asking for a bond in the ballpark of 5,000, 10%. Court is, as far as I can tell, made its ruling, so.
All right, thank you. Look, you're in a tough spot. He never absconded. He lives in Three Rivers, has for a long time. But he doesn't always show up when he's supposed to. Mr. Marvin's got strong feelings about this. He opposes it. We don't exactly know what happened. So Mr. Cap, the bond remains at $15,000 cash or surety. The bond motion will be heard next Tuesday by Judge Pattison as part of the pre-exam or preliminary examination. All right, Mr. Cap, your friends are here. They heard everything that just happened. I won't be here next week, but you'll see Judge Pattison. He can hear the proofs on the felony case. And they can again argue the issue regarding bond. You're good to go.